My name is Rakim Brooks. I'm president of the Alliance for Justice, and this is our regular series, Holding Court. I have our esteemed guest, Michael Waldman, a friend and comrade in the cause, president of the Brennan Center for Justice. We're just going to give it a few minutes to let people sort of find their way in, maybe just a minute or so. As we know, sometimes this new platform can be a little difficult as we all migrate away from other platforms that shall not be named. Watching the numbers tick up a little bit. Let's see when it gets to about 40 or so. We're at 25. That's a strong group. Michael, what's the largest audience you presented to thus far?
It's hard to know because it's all remote. But we have gotten folks from all over the world who are worked up about the problems with American democracy, and so we take them all.
Good. All right, looks like we've just about hit that number, so let's get started. Again, my name is Rakim Brooks. I'm president of the Alliance for Justice, which is an association of more than 150 organizations committed to building power, transforming the courts, and securing justice for all. As I began, I said today's conversation is part of our ongoing series, Holding Court, Justice Conversations with AFJ, which features leading activists, scholars, attorneys to discuss current political and social justice issues. And in Michael Waldman, our current guest, we have both an activist, a scholar, and an attorney. So we feel like we're checking all the boxes with this year-end event. Michael is here to discuss his latest book, The Supermajority, How the Supreme Court Divided America. Before we get to the substance of the book, let me just tell you a little bit about Michael. He is the president and CEO of the Brennan Center for Justice at NYU Law School. For those who don't know, though I doubt there's anybody who fits that category who's joined this call, the Brennan Center is a nonpartisan law and policy institute that focuses on improving systems of democracy and justice. They're a leading voice on voting rights, money in politics, criminal justice reform, and constitutional law. And Michael himself is a constitutional lawyer and writer who is an expert on the presidency and American democracy. He's been leading the center since 2005. We're grateful that he's stuck around so long in our movement. So, Michael, thank you for joining us.
It's great to be with you. I really appreciate the opportunity. And, the Alliance for Justice is such an important group. It's played such a really significant role in much of the history that this book talks about. But even more now than ever, we really need what you do, and Rakim, your leadership makes such a difference. It's such a powerful and fresh voice, and glad to work with you.
Well, you kind of say so, Michael. Well, let's jump right in. I mean, we'll start big picture first. I know folks have asked you why you've written the book, so I give you an opportunity to talk about that. But now you've been sort of on the speaking circuit, and I'm curious, what surprised you most about the reception for the book?
It's a great question. There's huge interest in it. People are fired up. They're unhappy. But they especially want to understand, first of all, has it been this way before, and what can we do about it? And when they learn both that these fights over the Supreme Court are not new, it's not some big transgression to criticize the Supreme Court, but it's actually been a central issue in American politics throughout the whole country's history, and that there are things we can do about it. They actually they come away not quite as gloomy as they were when they walked in.
Yeah. Well, that's good. And we're all
nothing else.
Exactly. We're all looking for inspiration at this point. I actually wanted to start with chapter 1. I told you I reread the book in certain chapters. And one of the things that was striking to me, maybe I'm in a mood. You and I are both lawyers, and we think of the law as being this vaulted profession, protecting rights. But your first chapter is, American aristocracy. And you point out that when Tocqueville was sort of tracing our early lands and engaging with different populations, he talked about how robust the democracy was. And he actually worried and said, there's no natural aristocracy to rein in the excesses of the populace. But we have lawyers. And so I wonder if that prompted anything in you as you reinvestigated that sort of history, that there's a way in which we think of lawyers as protecting certain things, but Tocqueville seemed to have a different impression that maybe is truer to how we're experiencing our current judiciary.
And it's so true in all history, but certainly when you look at American history, that so much of the time when there are things that we think are new, they're actually recasting of existing social structures and existing power structures. And you're right, de Tocqueville, when he looked at democracy in America, this was kind of a new idea. It was something of a fad that you could even have a democracy, but he was worried about it. He thought there'd be a tyranny of the majority. And he said, basically, like you said, oh, in this country, the lawyers play a very outsized role. They're the aristocrats. He has a line that folks might have seen because it's so on point, which is that in the United States, sooner or later, every great public issue ends as a lawsuit. It's also the case that from the start, the courts and the legal system were not only some idealized kind of paragon of standing up for individual freedom, but they were there to protect the social order. They were there to protect property. And most of the time, even the U.S. Supreme Court maintained its role and its authority by not rocking the boat too much.
Yeah. And that's something you talk about early in the book, the idea that the Supreme Court has this grand pronouncement early in its history that it's emphatically their province to say what the law is. And you also point out that judicial review is rather American, but then they don't do much with it for, almost 60 years until we get to Dred Scott. Could you just inform the audience a little bit about, was that a political calculus? Was it somehow a holdover from the fact that judicial review was new and they didn't quite know what to do with it? What was going on that had this sort of, as I said, a grand pronouncement, but no exercise of that authority?
Well, you're right that we all know these quotes from Marbury versus Madison, and they're used by current Supreme Court justices whenever they want to congratulate themselves on doing something big. They quote it, or maybe people remember writing about it in high school history or something like that. It was a significant thing that they articulated the idea of judicial review, but it really wasn't used very much. The Supreme Court politically was very weak, and people did not assume that there would be a court system that would be in effect over the other branches of government. The part of the Constitution that talks about the federal courts is only 1/10 the length of the parts dealing with Congress and the presidency, which they back then thought would be both more democratically accountable and the main show. Marbury v. Madison, one of the things, as you might remember, was that they articulated the idea of judicial review by not overruling the Jefferson administration because they were so concerned about their weakness. The next time, that was the first time that a Supreme Court said a law passed by Congress was unconstitutional. It didn't happen again until the Dred Scott case. And that case that was
a bad time.
That was, it was, it gave it a bad odor for a long time. I mean, one of the things that was striking to me in looking at the history is most of the time, actually throughout the country's history, the Supreme Court reflects whatever the political consensus is in the country, or at least the elite political consensus. Sort of hugs the middle. And in a way, given how weak it is structurally, that's how it gets the credibility from all the rest of us to do what it does. But there were a few times, a fairly limited number of times, where the court was so extreme or partisan or activist that it overreached and it created a backlash. And the first really significant one of those, and really egregious, of course, was Dred Scott. That was the ruling in 1857, where there was rising agitation about slavery, and the Underground Railroad and the Fugitive Slave Act and all the things that were going on. And the Supreme Court got it in its head that it was going to, quote, solve the problem, meaning not the problem of slavery, but the problem of controversy over slavery. And that was the decision where they said that Congress did not have the power to prohibit slavery from the territories, meaning they couldn't limit it to the South. And worse than that, that Black people could not be citizens. They had no rights to be citizens. And one of the things that's noteworthy is it was an extraordinarily controversial decision. I mean, the backlash led to the rise of the Republican Party and actually the election of Abraham Lincoln as president, and ultimately, in a sense, to then the end of slavery. But it was a huge political issue. It was also, interestingly, the first major Supreme Court opinion to leak.
Hmm.
It didn't leak to Politico. It actually leaked to the incoming president-elect, Buchanan, who wanted them to issue this ruling to kind of take the issue off his shoulders. And he got up and gave his inaugural address and said, well, we all know the Supreme Court is going to make this big ruling on slavery. None of us know what it's going to say.
Right.
So let's all just agree that whatever it says, we're going to go along with it, right?
Right.
That, the newspapers the next day all said, "Oh well, now we know what it's going to say." So it was such an overreach, but the response critically was not just sort of by lawyers or judges. It was not with footnotes. It was in the streets. It was in the ballot box and political parties, and that's actually happened a few times in the country's history.
Yeah. Well, you brought up Abraham Lincoln and his election, and this is something else that your book reminded me of. I guess I had a sense of it, but it wasn't as clear. You went back at one point early in the book and you quote famously Federalist Paper 78. And the thing I noticed, which I don't know why I'd never paid attention to before, is, Alexander Hamilton says, it may truly be said to have neither force nor will, but merely judgment. And most of us kind of end the sentence there. And then you say, then it says, and must ultimately depend upon the aid of the executive arm for the efficacy of its judgments. And that really caught me, because the way you set up the book, even before Abraham Lincoln, is it's the Jeffersonians who fight with the court first. Then it's the Republicans who fight with the court, first starting with Lincoln and eventually Teddy Roosevelt. And of course, then the Democrats are fighting with the court. William Jennings Bryan doesn't become the president. He becomes the presidential nominee, but not the candidate. And then, of course, FDR against the old 9 men. And so when I went back to that statement, I thought, aha, like maybe this has been told us all along. It's not just that we have to have faith in the decisions of the court, but rather that the executive branch is in fact meant to check the court in ways that we may have somehow lost. So that's a big, overwhelming kind of set of things. But I'm just showing you where my mind went in trying to pull together different threads. Maybe you could just talk about how presidents have related to the court, because we often think, I think in our generation, that the president is supposed to step aside and allow the court's judgment to have sway over the nation. But for most of our history, that wasn't the case on the big issues of our time.
That's exactly right. And that's a really important point, and raises so many questions for today, including where's Joe Biden?
Right.
But it was seen as both appropriate and not transgressive. But what presidents did was at times they took on the Supreme Court. That it was not this idea that the Supreme Court would make a big grand ruling and then everybody else was kind of obliged to kind of tug their forelock and be deferential. Presidents, not just movement activists, but presidents themselves often took on the court when it overreached. So Lincoln, in his inaugural address 4 years after that, the inaugural address with the leak, Lincoln actually said, with Roger Taney sitting there, the Chief Justice who wrote Dred Scott, Lincoln said, there are some people who say that the Supreme Court alone decides what the Constitution means. That doesn't make any sense. They're not elected. What kind of democracy would we be if we just let the Supreme Court do that without all of us having a say? Teddy Roosevelt, as you said, to a much greater degree than I realized before doing some of the research for the book, the next period where the court was out of step with the country in a lot of ways was the Progressive era. This was, of course, a time of great industrial change, of widening inequality of wealth, of immigration and urbanization and all the stuff we know about, a lot of which looks like today. And the Supreme Court of that time, the elitos of that court, they felt that their role was to make sure that government couldn't do anything about it, couldn't do anything to protect workers, to protect the environment, and so on. And they issued a bunch of very tortured rulings. Lawyers know this as the Lochner era, after one of the notorious cases. And to a much greater degree, I think, than people would expect, Teddy Roosevelt, his 1912 presidential campaign, that was this very storied election where he was challenging his handpicked successor, Taft, and Woodrow Wilson was the Democrat, and there was Eugene Debs was a socialist who was the candidate. They don't make presidential elections like that anymore. But Teddy Roosevelt, his most controversial big proposal was taking on the Supreme Court on the Lochner case and these other things, attacking its reactionary rulings. They had a bunch of ideas that were pretty out there, but he understood that this was what people appropriately should be yelling about and voting about. And so when we all know a bit about the New Deal fights, when his cousin Franklin also took on the court, they struck down the first New Deal, and then they were getting ready to strike down what's called the second New Deal, including Social Security and the labor laws. And FDR proposed expanding the court. It was called the court packing fight. They had this big, confrontation, and Roosevelt lost, but the court also backed down. But it was a real continuation of this fight that had been going on for years and years, and that was part of what it meant to be a progressive at that point. And the third time where the court was out of step, I would say, in some ways with the country, and it's a little more complex because it's the Warren Court and certainly the aftermath of the Warren Court. Now, I run the Brennan Center, which is named after Justice Brennan, who was the mainstay of the Warren Court. And of course, I at least think so many of the rulings of the Warren Court were so important and necessary. It began with Brown v. Board of Education, and everything from New York Times v. Sullivan, protecting freedom of speech, to the one person, one vote cases. But when you take a step back, and I liked so much of the substance of what that court did. But when you take a step back and look at it, the volume of stuff they did, the audacity with which they made these rulings, it created its own backlash. It began to seem illegitimate to a lot of the country. And part of what was articulated in response to that was also presidential politics. Richard Nixon, when he ran in 1968, a lot of what he talked about was changing the Supreme Court and getting strict constructionist judges, as they called it. Yeah. So presidents, again, didn't think it was inappropriate to take on the Supreme Court. And that was at a time when it had a great deal of reverence for it because of Brown v. Board and the other civil rights cases. When you think about who did Lyndon Johnson turn to investigate the Kennedy assassination? Right. Somebody who he thought everybody would trust. It was the Chief Justice of the United States. That's a sign of how universal the reverence was, even as they were making all these big rulings.
Yeah. Well, I'll say, in both reading your book and hearing you sort of resuscitate that history, it strikes me that feels like a much healthier constitutional balance. I mean, you've got separation of powers for a reason. We expect the branches to war with one another to some extent. And I've just been pondering, not for long, so maybe you have an answer to it, what was broken? And it seems like, Richard Nixon broke everything in the 20th century, right? So it feels like Watergate kind of broke it, that the lack of confidence in a strong executive. And this is something that we liberals, of course, are always complaining about, the strength of the executive, its war powers, et cetera. But in this particular context, I was wondering if the lack of esteem for the executive actually meant that we offset the balance, that suddenly the court, because it had stood up to Nixon, found itself for the first time in the eyes of the public with even greater respect than the executive branch. But I don't know. I've just started to think about it.
It's an interesting thing to think about. I mean, one of the other high points in terms of the court's public profile was the case U.S. v. Nixon, where they unanimously ruled that the president, Nixon, had to turn over his tapes to the special prosecutor, which led pretty quickly to his resignation from office a few weeks later. And that was also seen as a high point, and that was also when they were quoting Marbury v. Madison, and say, the case where they really articulated this idea that they were the ones who were going to say what the Constitution meant, and everybody needed to sort of salute, was a case called Cooper v. Aaron in 1958, and of course, this was one of the great civil rights cases. This was the Little Rock High School. Central High School case, where they said everybody, lower courts, need to follow our interpretation of the Constitution. And, a whole generation of lawyers, but really of Americans, grew up with this reverence for the court, but also this idea that they were no longer a co-equal branch, but sort of a supervisor of everybody else and a legislator.
Mhm.
When they started then making politicized rulings, that became more of a problem. And I think that one thing that happened was there were a lot of rulings in the 60s and 70s that were, where the court was part of the massive social change, but it was sort of social change that was roiling the country in a lot of ways, but pretty quickly got co-opted by the same moneyed interests that typically were what the court would defend. So you think about the advances of freedom of speech, but where that had a particularly significant impact was in a case called Buckley v. Vallejo, which was the case that made it very hard to regulate money in politics.
Right.
One of the justices actually said at the oral argument of the case, "Oh, money is speech and speech is money" in campaigns, and the very big money dominated political system that we have now is a result of that. And so Barack Obama, interestingly, and Ruth Bader Ginsburg separately talked at earlier stages in their career about that it was a mistake for liberals, for progressives, to be so focused on litigation as their way of trying to get social change, partly because if the answer is distributive, if it's spending money in a certain way or building a government program, the courts are just not good places to set that up. And partly too, because it winds up feeling less legitimate to people, feeling less small d democratic, and people lose their democratic muscle memory of how to actually be advocates. Something, by the way, the right wing remembered to do.
Yeah, absolutely. But since we're on the political piece and you led into it nicely with something that the right wing remembered to do, one of the striking earlier passages is where you say that, I guess, the presidency has changed hands 6 times or so from one party to the next, and yet the Republican appointed majority has remained the same, and that's an aberration in our history. And I wondered if you could just talk to, well, what were the processes that drove that? Any friends of the Alliance for Justice or the Brennan Center understand what might have been?
It's so interesting because when you really look at the partisan implications of this, it can kind of blow our minds. It's impolite to whisper, talk about this stuff in law school seminar rooms. And all this predated Mitch McConnell. So Democrats, one party, let me take it back even a little more. We have all these aspects of our constitutional system, and folks have been really focusing on this in recent months. All these aspects of our constitutional system that empower minority obstruction or empower a minority. And for a long time, a lot of these things were they were okay, or they were sort of quaint Americana, but now they're really combining, almost conspiring to entrench the power of the political minority, sort of a racially dug in white backlash to a lot of the change that's happening. So, everything from the existence of the United States Senate with the same representation for every state. At the beginning, the biggest state was 13 times as big as the smallest state, but now California is something like 70 times bigger than Wyoming. So that's been around for a long time, but the impact is a lot bigger than it was. The Electoral College, it used to be an afterthought. It followed the popular vote for about 120 years. And then, of course, we know that that's not happening these days. And twice in this century, the loser was elected of the popular vote, became president anyway. Gerrymandering's been around forever and ever, but it's getting worse. And among other things, the way the Supreme Court is set up and the lifetime terms and the way they get appointed. So this is a factual statement, not a partisan statement. One party, the Democrats, have won the popular vote in 7 of the last 8 presidential elections. That is the longest winning streak of that kind by far in American history for one political party. But the other party appointed 6 of the 9 justices. And as you said, the parties have kind of split control of the White House more or less for the last half century. But the last time a Democratic president had appointed a majority of the Supreme Court was 1970. And this blew my mind, this fact. The last time a Democratic president appointed a Chief Justice of the United States was 1946. That's crazy. And that all, like I say, that all predated Mitch McConnell. Some of it was bad luck. Some of it was emphatically a greater focus on the courts by the conservatives and the Republicans than their counterparts had. But some of it is just this kind of weird system we have that allows for that and that enables this unaccountable branch with unelected justices serving for lifetime terms to be captured by a political faction.
Yeah. Well, the Brennan Center has been one of the leaders now on the concept of term limits. And there was a recent Washington Post op-ed written by someone we both respect, Danielle Allen, who's written on the Declaration of Independence and is a great political theorist. And she says that the court needs term limits and the justices could impose it on themselves. And I don't believe they ever would. But one of the things it raised for me, similar to your earlier piece about how the court can be out of step with the public, is that we expect our political officials, and I'm going to call judges political officials just because they're part of the political machinery as such, not because they're elected, but our political officials to exercise some form of discretion, some form of self-regulation, and it would seem knowing when to go would be one of those things that we would look to. And it made me think maybe the system's been broken for a far longer time than we've thought. I mean, from the time that justices, regardless of political party, just began to hang on to the very end until death, it might have led us to think something's not quite right with these people and the kinds of folks we put in these positions, because they're no longer stewards of the institution. They are the institution. So thoughts, reactions. I know that, as I say, you all have been big on term limits.
Yeah, no, and you're right that, for example, William O. Douglas is an example of somebody who stayed on till he was basically not able to do his job. And there have been other examples. The idea that nobody should have too much public power for too long, that's pretty basic value baked into our system. And in a sense, if you think about it, that was the lesson George Washington taught us when he stepped down as president after 2 terms, when he could have certainly have served longer. And it was one of the extraordinary, he obviously had a lot of pluses and a lot of minuses. But one of the positive things he bequeathed the country was this idea of stepping out of power. When you think of how many other revolutionary leaders in world history, revolutionary generals elected unanimously, they don't usually do that. But he did. And the idea of term limits is that it's a basic aspect of accountability and of making sure that these folks just stay somewhat in touch with the country that they're serving. They're not elected, of course. They serve for life, at least as it is currently done. You could, I had not thought so much about the idea that they could impose term limits on themselves, but certainly they could, although it would be hard to enforce it in a binding way. But Congress, we believe, certainly it could be done, an 18-year term limit could be done by constitutional amendment. We also think it could be done by statute. You basically say that after 18 years, justices, like other judges say, become senior justices. Their role changes, the type of cases they hear change. It basically creates the term limit. And one thing that's interesting here, the sort of universally understood nature of it and the values behind it is term limits are really popular. They're popular with Republicans and Democrats and independents in ways sort of that I think the pundit class would be surprised by, because we assume everything's so divisive. I found this out when I was a member of the commission on the Supreme Court that President Biden appointed a couple of years ago. And, these commissions, they don't always do very much. And this one was actually instructed at the outset not to make recommendations. Right. And we didn't. government agency that worked, as intended. But it was interesting because we heard from dozens and dozens of public witnesses. I'm pretty sure the Alliance for Justice testified from left and right, and people had all different kinds of views on court expansion. Some were for it, some were against it. Jurisdiction, ethics, some were for it, some were against it. Over and over again, the witnesses said, "Oh, but I'm for term limits, of course." There were conservatives as well as the progressives. It's sort of a consensus in plain sight. Now, look, I'm not under an illusion that it's going to be a big group hug when it starts to move. But I think there's actually a lot of public support for it. And sooner or later, it'll be part of the reform agenda.
Yeah, I think so as well. And as you say, I think it's so embedded in our sense because of George Washington that that the term limit itself is a check on government power that I suspect many people in the public would be enthusiastic about it. Just so folks know, we're going to turn to your questions in just a moment, but we've sort of been doing a historical overview, and I don't want to leave without giving Michael an opportunity to talk about the current views. So speaking of term limits, the longest serving justice is Justice Clarence Thomas, who, as everyone knows, the Alliance for Justice has asked to resign given his recent ethics scandal. But there's a piece of your book, Michael, that really is exploring what it means for this to be the Thomas court. Of course, Chief Justice Roberts is the chief, and usually for most of his tenure had been in the majority and therefore presiding over large changes in American law. But now it's a 6-3 court, hence why you call it the supermajority. And Justice Thomas, when there's a disagreement between Chief Justice Roberts and the rest of the right, is the person in charge. So I thought you might just sing a few bars about that and what it's meant for our current jurisprudence and our democracy.
Well, he's literally in charge when Roberts is not in the majority, as in the Dobbs case. Thomas is literally in charge in terms of making the assignment of who writes the case. But even more than that, his ideas have come to take hold in the court. And for the longest time, Thomas was an outlier. He was almost an eccentric. He was on the fringe of the court. He held the view that, as he puts it, he said, "Stare decisis, precedent, following precedent, is for when we don't want to think." For suckers, for lazy people, basically. His vision of originalism is very much, he goes back, he looks at what he thinks the founders meant, or the founding generation meant, and then he'll rule that way, even if 2 centuries of practice has said something else. It was always a very extreme approach. He would go off and write his own concurrences, but now increasingly, on these big cases, especially the 3 big cases that I read about in the book, in the first full year of the 6-vote supermajority, which ended in June 2022, the 3 big cases of Bruin, which was the Second Amendment case, and Dobbs, and the regulatory case, West Virginia versus EPA, Thomas was in the majority, and his ideas, as extreme as they were and still are, held sway, and it was the basis for a very extreme court.
Yeah, absolutely. And one of the things that, let me actually jump to recent events. There was a recent article, I don't know if you had a chance to read it yet, by Politico, describing the kind of amicus process with Leonard Leo in particular and its relationship to the court's rulings, those 3 in particular that you're describing. And one of the things I've always been curious about is, in reading your book, it sort of gave me a sense that maybe I was wrong about this, but I'll just ask the question, is Justice Thomas sort of shaping the Federalist Society or the rights agenda, or is he being shaped by it? Or how do you see those 2 things in concert? Because the Politico article kind of suggests here these arguments are being served up, and they sort of take them hook, line, and sinker and pull them into their opinions. But of course, one of the responses from the right is often, these are free-thinking people who make up their own decisions. And so you're an analyst of the court. To what extent do you think, how would you judge the conversation, the interchange between the political movements?
Yeah. Well, so I think a couple of things. One is that if you look at the overall federal courts, one of the things that's happening, and of course the Alliance has been so active and so wise on the need to have judges, not just at the Supreme Court, but at all federal courts, be people who believe in justice, who believe in equality, who believe in democracy. You're seeing more and more absolutely kooky rulings from lower court judges, and they're often people who were Thomas clerks, or who are basically reading hints and signals from Thomas and Alito and some of the other justices of, hey, why don't you try this one? Why don't you try that one? And so his impact even extends beyond the court itself to the rest of the federal system. But I think it's also true, and it's hard to kind of fully unpack this. It's also true that the role of the Federalist Society and its drive to remake the federal courts is also something that is unprecedented in American history, and it's one of the reasons I think we're in another moment of overreach and backlash. But we've never had anything like the Federalist Society before in American history. The court has been captured, I would argue, by a faction of a faction, and it started as a student club, and it recruits judges. It runs ads through its network of affiliated groups. It runs ads on behalf of the judges. It vetted the justices, explicitly vetted the justices for Donald Trump when he was a presidential candidate and then in the White House. And then, as that article talks about, there's a whole series of organizations, some of them are just pretty much AstroTurf, filing the cases and filing the amicus briefs before the judges that they ran tens of millions of dollars of ads to back their nomination when they gave their name in the first place to the White House. It's a political machine of a kind, Tammany Hall style machine that we haven't seen take over the judiciary before. And it's also a very, not just a well-oiled machine, but as you know, it's a very well-funded machine. And we all used to sit around looking at the Federalist Society a few years ago and say, wow, they're really effective. And they don't, if you look at their public disclosures, they really don't have that much money. They don't seem to be spending that much money. Well, it turns out a couple of years ago, some guy secretly gave Leonard Leo $1.6 billion with a B dollars to spend on his network of organizations. So I guess they're not actually lacking for money yet. The Thomas stuff, a lot of it, the ProPublica articles actually came out after my book was published, or around when the book was published, but we'll be in the paperback, which is coming out in June. And these are not just ethics foibles. What we learned about Thomas is really quite extraordinary. I mean, it's not just the trip. One of the trips would have cost $500,000. It's not just that he covered it all up. He disclosed the funds he was getting from Harlan Crow until 2002, and then the Los Angeles Times wrote about it. And his response was not to stop taking the money, but to stop disclosing that he was taking it. But it's not just that. It's this guy bought his mother's house, bought Clarence Thomas's mother's house with her living in it and renovated it. And he paid for the education of Thomas's surrogate son. And if we looked at some state capital, Albany or Springfield, Illinois, or Trenton or whatever, and this was a state legislator and the local rich guy was keeping him in style in that way, we would say, look, this is the oldest corruption story in the book. I mean, it's extraordinary bread and butter corruption. And that the arrogance of assuming it was okay and that nobody would notice. And the through line here with the Federalist Society, as you know, is when you look at that extraordinary article, the first one by ProPublica, and I certainly hope they get a Pulitzer for it. One of the things that accompanied it was a painting, and it was a painting of Harlan Crow and Clarence Thomas at this luxury resort, and they're smoking cigars, and sitting next to them is Leonard Leo. And this is they each get a billionaire friend.
Yeah, no, I was just saying, folks should know this isn't just something that ProPublica illustrated to make us, help us to understand what the scene must have looked like. It was an actual painting that existed.
They found it on the internet and the website of the artist.
Right.
Yeah. Exactly. No, it's hung proudly somewhere, presumably up at that resort. And Leonard Leo is just a ubiquitous figure here. And again, it's noteworthy that Congress is finally fitfully investigating some of these issues. That's entirely appropriate too, by the way. There have been other investigations by Congress of potential corruption in the Supreme Court. That's how Abe Fortas was pushed off the court, for example, in 1968. That is not a transgression either. There's this mystification around the court, the idea that it's this holy institution. They wear robes, but they're not wizards. They're not in a religious order, and it's entirely appropriate for Congress as a co-equal branch to pass laws or regulate their ethics or investigate as appropriate.
Totally. I mean, one of the pieces you have early in the book, and then we should get to questions, maybe one more after that, just talks about how the early court was sort of staffed by the railroad baron lawyers, basically the industrialists and the robber barons of that time, putting their friends on the court. And this so harkens back to that it makes it feel, what you and I are saying, the eloquent description you just provided, has somehow been painted as radical, when in fact all you're calling for and all I'm calling for is good government and obvious non-corruption.
This is a branch of government. Right. There are a bunch of government officials, for better or for worse, very powerful. That's all they are. And they only have the power that they have because we, the people, give it to them. And look, we want an independent court system. We want a court that will protect people's rights. We want the checks and balances. But we have to see the kind of decades-long PR operation by justices of all political stripes to kind of mystify what they do. And then every once in a while, the real political dimensions of it become visible.
Totally. Well, let's just fast forward a little bit. You mentioned that the paperback is going to come out in June. And I know you said you'll talk some about the ProPublica pieces, probably about some of the cases that have come out since that time. You want to just give the audience a brief preview, another reason to if they've already bought the hardback like I did, to go ahead and buy the paperback as well?
Absolutely. It's a wonderful set to have. Thank you. So, the three big cases that I mentioned in June 2022, which was when the court really said, well, look, we're originalists. We're going to make our decisions only based on what the history and tradition is, meaning what the social views of property owning white men in the late 1700s, by and large. That was the Bruin case, which was by far the most extreme Second Amendment ruling in the country's history. The Dobbs case, which of course overturned Roe v. Wade and Casey, and reversed the constitutional protection in the U.S. Constitution for abortion rights, and the West Virginia versus EPA case, which was a case that began the assault on the administrative state, on government's ability to protect public safety, public health. That was all in 2022. In 2023, this past June, of course, the biggest case was the affirmative action case. Right. And this was not a surprise in a sense, but it was another bit of the political agenda of the right being put into action. The court undid the admission systems of all the private universities, saying, "Oh, this is you can." Diversity is a wonderful thing. It's great to try to have diversity. You just can't mention race. You just can't have race as a factor in understanding diversity. And as you know, Justice Ketanji Brown Jackson in the oral argument asked a pretty piercing question. She said, so wait a minute. So let's say there's at the University of North Carolina, there's two essays. One is from someone who says, I want to go to UNC because my granddaddy went to UNC and it would mean a lot to me to go to UNC. And the other person says, I want to go to UNC because my grandfather couldn't go to UNC because he was Black. Right. And therefore that person or she could not say that in their essay, or that essay couldn't be taken into consideration. So the court kind of tangled itself up a bit, saying, well, you can have essays, but it really is going to have a big impact, not just on higher ed, but you're now seeing the same right-wing organizations that brought that case suing to undo DEI programs. So certainly they will go after government contracting set aside. and all these other things that are part of the structure of society, and where private sector and governmental actors have tried to address the legacy of discrimination or the evolving diversity of the country in various ways, and the court has sort of inserted itself. The other cases, though, that are pretty big from this term, which were actually a positive surprise, at least in one case, a positive surprise. So, we all thought, and in my book, I thought too, that the Voting Rights Act case,
Right.
Allen v. Milligan, as it eventually was known, would be the last death rattle of the Voting Rights Act, given the way the Supreme Court had gone after it over a decade under John Roberts's vigorous leadership, starting with Shelby County. And it was a real surprise, and a positive surprise, when, in fact, Roberts wrote the opinion striking down the Alabama congressional map, allowing the Voting Rights Act to be used, Section 2, which lets people bring lawsuits. It was a real surprise, and you have to wonder if the political tumult over the court had something to do with it. The other big one was on democracy issues, was Moore versus Harper. That was the independent state legislature case. This idea, which we've talked about a lot, that somehow that the Constitution had given state legislatures the exclusive power to set rules for federal elections with no checks and balances from state courts or state constitutions or governors or the voters, and that nobody had ever noticed it before now. Right. This was an absolutely nutty fringe idea, and it would have brought chaos to the electoral system. And in that one, they ruled 6-3 that this rejecting it. But in both these cases, that wasn't a surprise in the end, because the weight of scholarly and public opinion was so strongly against it. But before people celebrate too much, all these two cases did was leave things alone, was ratify the status quo. They weren't some big grand new expansion of voting rights. In this instance, the court decided not to do the damage it had been doing more routinely other times. So, I think the court is moving to the right. It wants to move the country to the right. Roberts wants to keep his hand on the steering wheel as much as he can and his foot on the brake, but the direction's the same.
Totally. Well, this has been a great discussion from my part. I want to make sure that the audience gets in. Maybe the first question is actually about Justice Ketanji Brown Jackson serving as a member of the court. And it says, how has Justice Jackson's background, along with President Biden's call for professional diversity, impacted the bench? I know this is a glass half full, glass half empty kind of story, but I'll let you break the news.
Well, it really is significant, not just that she's a Black woman, but also that she was a public defender. And one of the things that the Biden White House has done with the Senate Democrats that's been really good is they've been energetic about filling a lot of the judicial seats, although not so much in the South, where the political backlash is stronger. But the word went out that they didn't just want corporate lawyers. They didn't just want prosecutors. They wanted people with professional diversity, as you say. And so you see people like Myrna Perez, who was the longtime head of the Brennan Center's voting rights program, is now on the Second Circuit Court of Appeals. Dale Ho, the head of the voting rights program at the ACLU, is a trial judge. It really is an extraordinary thing, and it comes in part by the willingness of this White House to take this more seriously than other presidents have, but also the fact that there's no filibuster anymore. And allows these kinds of nominations to go through. In terms of, you remember, of course, President Biden, when he was running, pledged to appoint a Black woman to the court. And then when the seat opened up, he said, yeah, I'm going to do that. And then she was the front runner from the beginning, because she'd been a trial judge and an appeals judge, and people felt she was the likely person. But as you remember, Ted Cruz and Hawley and all these other people pretended to be all upset and got the vapors about how terrible it was to say that a Black woman would be appointed, and this is just racial preference. And it was such rank hypocrisy when you again look at the history of the country. Presidents have always considered demographic, political, geographic diversity when making and considerations when deciding who to appoint to the court. For a long time after the Civil War, there was always a Southern seat. There was a Jewish seat, starting with Brandeis. Brandeis was appointed by Wilson as a way to appeal to the swing vote of Jewish voters in swing states. Reagan, Justice Brennan, who the Brennan Center is named after, was appointed by Eisenhower without so much as a job interview because he wanted a Catholic Democrat from a swing state in an election year. And Reagan explicitly in 1980 pledged to appoint a woman. We think about this with Justice O'Connor's recent passing, because his polling was doing badly with women. It was the first time you had the gender gap. And so he said he was going to do that. And so the idea that this was some big transgressive thing, it was just absurd. You know, and I think she's clearly so sharp, so strong. She's really increased the energy level, among other things, I think, among the dissenters on these cases.
Yeah. One of the striking images you drew at a point in the book was the fact that the three dissenters in the big cases, one a Latina, one a Black woman, and one a Jewish woman, facing off against the conservative majority. Did that conjure anything for you emotionally? I mean, how the country will receive that as the years go on?
You know, it's really, it's a tremendously interesting thing to think about. Because on so many cases, it's going to be the three women are not always, but the three, when there's a 6-3 vote, chances are pretty good it's going to be the three women who you mentioned. And it both kind of clarifies in some ways the stakes and sort of who's benefiting and what vision of the country is being put into place. This idea, the originalism, the idea that you know what the guys in powdered wigs back in the day thought what their social views were is how we have to govern ourselves now. It's also, you know, it could also lead to greater polarization as people, you know, as people look at it as ever more polarized and partisan. But it is a noteworthy thing. Now, of course, Justice Amy Coney Barrett is very often in the majority on these matters, and it's an interesting fact right now that with 4 women on the Supreme Court, we're much closer to gender parity on the Supreme Court than we are, for example, in Congress, or most state houses in the country.
Yeah. Next audience member's question, we'll probably just get 2 more in. We talked about this a little bit, but obviously the court has just passed the Code of Ethics. Our commentator says it has some colorful language for describing it, but how should Congress and President Biden respond if you have thoughts about that? The court has now said we're poised to control ourselves with a lot of shalls and not too many shoulds. But in any case, you know, Chairman Durbin has indicated that their work will continue. The president's been silent about it. So what are your thoughts?
Yeah. So, you know, without a doubt, Congress has the power, has had the power to pass an ethics code for the Supreme Court. Up until now, the Supreme Court was the only court, federal or state, that had no binding ethics code at all. This was something that had to change from the hardback to the paperback. Now it has one of the weakest. But it was always the case that the court could do this itself. It didn't need Congress to act, even though Congress did have the power to act. It's passed ethics rules for other courts and all other kinds of things like that over the years. You know, it seemed for a long time as though Roberts was just being sort of timid. We knew that there were at least 4 justices who publicly had urged a code of ethics. All the other federal judges have to do this stuff. But what they finally came out with has correctly, in my view, been derided as more loophole than law, as very weak. It has no mechanism to enforce it. They didn't bring in former justices or retired judges or any of the other ways that they could have somebody advising them even, or looking over their shoulder. It's basically still the case that Clarence Thomas and the rest are policing themselves and in effect saying, trust us. And, you know, so Congress still can and still should pass something stronger. And it is also appropriate, I think, that they issue subpoenas like they have to find out more about Harlan Crow and Leonard Leo and their potentially improper influence on all this kind of stuff. So, you know, I don't think that the court, if they thought they said they were only doing it to, quote, clear up the misunderstanding by the public that they had some ethical problems. I don't think that misunderstanding has gone away.
Yeah, I would agree with that. This last question is so good, I've just got to ask it. They said, you cite to some of what Justice Sotomayor said during oral arguments in Dobbs' case, quote, will this institution survive the stench that this creates in the public perception that the Constitution and its readings are just political acts? I just don't see how that's possible, end quote. But the person follows up, why don't they just leave? I mean, aren't they standing up this charade by continuing to rule alongside their colleagues when in fact they know that this is just politics as usual and the court has lost its majesty? I've added a little bit, but that's essentially the question.
So it's an interesting question. You know, I mean, they don't look too happy.
They don't look happy at all.
You know, I wouldn't be surprised if this thought has flickered through their own heads. But I think that the pep talk I would give them is that the role of articulating principled and tough-minded dissents is a really important role. This is a public forum, and the arguments that they make now will be heard and will resonate and will become things that people pick up and carry as political arguments. Certainly, again, the conservatives understood that. And a lot of the time during the country's history, some of the things we remember, of course, are the dissents. We remember Justice Harlan's dissent in Plessy v. Ferguson, but even beyond that, the great progressive justices of the progressive era, Brandeis and Holmes, they were especially known for their dissents. And it was like if they had a hashtag back then, it would be Holmes and Brandeis dissent. It was a big deal when they dissented in a case, and they made these arguments really strongly, really compellingly. I would say to those justices that understanding that their audience is not just the other justices on the court, but the rest of the country, should affect how they write it, what they say, the length, the number of footnotes, all that kind of stuff. It can actually be a really important role, though. It's heroic service, because I wouldn't want to be locked in a room with, you know, Sam Alito for the rest of my sentient life either. But it's an important role for them to play.
I think we'll end there. I wouldn't want to be locked in a room with Sam Alito. Thank you all for tuning in. You should be sure to follow the Alliance for Justice and the Brennan Center on social media to stay up to date on our future events. To do so, you can visit afj.org or brennancenter.org for more information on our organization's priorities and to sign up for our newsletters. Michael, thank you so much for joining us today. As I said, this is an extraordinary book. For those who read it, you will notice that without footnotes, he is citing to so many other books that he had to read in order to write this one, because I've read a bunch of the other ones, so I could trace some of the lines of thought. So it really is a heroic and comprehensive work. Thank you.
Thank you. It's great to be with you. And again, as I said at the beginning, the Alliance under your leadership plays such an important role. We're really glad to work with you.
Yeah, it's the same. So please do be sure to pick up your copy of Michael's book, The Supermajority, How the Supreme Court Divided America, at your local bookstore, online, etc. And you might just hold out, I don't know if this matters to Michael, until June when the paperback comes out, since there'll be additional content that, as we know, will be really valuable. For everyone, our next holding court is Tuesday, January 23rd, 2024 at 2 p.m. We'll be having a discussion with Joel Anderson, staff writer at Slate and host of Slate's podcast, Slow Burn. In season 8 of Slow Burn, Joel did some outstanding reporting on the life of Justice Clarence Thomas. We hope you'll tune in. Thanks, everybody.